So after the part 1 and part 2, in which we discuss the union and its territory, and then we discuss the citizenship, today we are going to start with part 3 of the Indian Constitution, that is fundamental right. We will take the clue of that particular article from here, and then we will discuss what that article actually means. So I will be stating it. So the first, when we start with fundamental right, the first article that comes is the Article 12 of the Indian Constitution, which state that in this part, unless the context otherwise require, the state include the government and the Parliament of India, the government and the legislature of each of the state, and all local and other authority within the territory of India or under the control of the government. It told that the state include the government and the Parliament of India, the legislature of each state, the local authority, and the other authorities which are either within the territory of India, okay, or they can be in a foreign territory also, but if they come under the control of the government of India, we state that or under the control of the government of India. So even if they are in a foreign country, but if it comes under the control of the government of India, then it will be regarded as a state. That is the most important thing whenever we discuss the cases like Keshwanan Bharti versus state of Kerala, or Jagmohan Reddy versus state. So state here is the parliament, the state legislature, the local authorities, and other authorities. Now we will discuss. We know the Parliament of India, that is Lok Sabha and the Rajya Sabha. We have the legislature of the each state, where we have the legislative assembly, and in 6 states we have the legislative council. The latest is the West Bengal, which has passed the resolution, but it has to be passed by the 2 houses of the parliament. And then we have the local authorities, which is the municipality and the panchayati raj. As we know, we will be discussing this in the when we will be discussing the important amendments. So no need to write now. Just for the sake of introduction, I am giving it. The 73rd and the 74th amendment to the Constitution talks about the. This is the 73rd talks about the panchayati raj, and the 74th talks about the municipality. So these are the local authorities. For example, you must be having your own municipal corporation, okay, and those who belong to the village area, they must be having their panchayat, है ना, panchayat mukhya. And you must have seen, I hope, means I guess you have seen the web series Panchayat, okay, that is by Jitu Bhaiya of Kota Factory. There is a web series also of Panchayat. So all these are the local authorities which come under the local authorities part of Article 12, that is the state. Now what are the other authorities? Here the other authorities are all the education institute or any complex or any organization that is working under the control of the government of India, which is under the control of the government of India, are considered to be the other authorities. Okay, like whether it is the institution, school. Now those school which are aided by the government of India. Okay, the school here means those school which are aided by the government of India. Only those schools. Then you have the other organization which are under the control of the government. So this is Article 12, which talks about the state. So if the question comes, which article of the Indian Constitution talks about the state? That is Article 12. Now 3 cases we will be discussing. The very famous 3 cases. First is the Rajasthan Electricity Board. So if you are a Clat aspirant, you don't need to remember the case now. You can write it down for the sake of your future law study, because knowledge will never be a waste. But if you are in the law school, this is a very compulsory for you to know the case. So Rajasthan Electricity versus Rajasthan Electricity Board versus Mohanlal case. Okay, this is a case of 1967. It is a case of 1967, in which it was held by the Supreme Court that it is not only, means when we call a state, it does not mean that it has to perform a sovereign function. In this case, Rajasthan Electricity Board versus Mohanlal case 1967, Supreme Court told that it is not compulsory that for a institution or organization to be called a state, it should be doing a sovereign function. It was in this case that the Supreme Court told that even the institution, the organizations which are working for the promotion of the economic interest of the weaker section, or for the people, for the public, they will also be considered as a state if they work under the government. So they talk about in which the Supreme Court talk about the organization which are working for the commercial activities, for the educational purpose, for the economic interest of the weaker section of the people, they will also be considered as a state. So this was in Rajasthan Electricity Board. So it is not necessary that the particular organization should be functioning as for a sovereign function only. Then in that case only it will not be considered as a state. Next we have, yeah. After that we have the case of G Telefilms Limited versus Union of India. This is the case of BCCI. Okay, this is a very prominent question that comes in examination, and even in the Clat you will be getting, you sometime get an article on this, that whether BCCI, okay, whether BCCI is a state or not. That is the Board of the Control for Cricket in India. I hope you must be knowing BCCI. So whether BCCI is a state or not. In this case, the Supreme Court held that BCCI can be considered as a state, but it can only be taken into consideration under Article 226 of the High Court, not under Article 32 of the Supreme Court. Now, what is this? See, whenever any of our fundamental right is violated, we can directly move to the Supreme Court, where Supreme Court issue it under Article 32 of the Indian Constitution that we are going to discuss today, if time permit. Okay, so 32 of the Indian Constitution tells that the moment a fundamental right of any citizen is violated, he can move to the Supreme Court, where the Supreme Court will issue it, or the particular person can move to High Court under Article 226 of the Constitution. Now, in this case, G Telefilm Limited versus Union of India, it was held by the Supreme Court that BCCI will be considered as a state only for the sake of 226 of the High Court. No petition can be filed against BCCI under Article 32. Means, what is the conclusion here? You are a Clat student, I know. So the conclusion here is that any violation of fundamental right under Article 32 or 226 can be initiated only against the state. It can be only initiated against the state. If the state violates your fundamental right, then you can move to the Supreme Court or the High Court. So in the G Telefilm Limited versus Union of India, Supreme Court held that BCCI will be considered as a state only for Article 226 and no petition can be filed against it under Article 32. After that, we have the very famous case of the A.R. Antule versus R.S. Nayak. A.R. Antule versus R.S. Nayak. This is a very famous case in which it was held that whether the question was whether judiciary can be considered as a state or not. So the Supreme Court held that when the judiciary is taking decision regarding the administrative power, or whether it is at the time of rule making, note it down, okay, when the judiciary is taking decision regarding the administrative work, okay, or regarding rule making. I am giving you the example of rule making. You must have heard the Sexual Harassment of Women at Workplaces 2013 Act regarding the Internal Complaint Committee. Most of you, those who belong to the Clat aspirant, you must have solved various passages on this. So this Sexual Harassment of Women at Workplaces Act, this is not an act by the government of India, that is the parliament. Means it has been brought by the parliament, but the guideline of this was framed by the Supreme Court. It was the Supreme Court which framed the guideline. Now this will be considered as a rule making function of the Supreme Court. So it was held in A.R. Antule versus R.S. Nayak case that when the judiciary is functioning as for the rule making or for the administrative power, it will be liable as a state. But when it is functioning for the judicial purpose, it will not be liable for the state. I hope it is clear that judiciary, when it is working for the administrative or legislative purpose, but for the rule making purpose, it will be considered as a state. But for the judicial pronouncement, for the judicial function, it will not be considered as a state. That is the whole summary of Article 12, which talks about the definition of the state. I hope it is clear.
Sir, I have one doubt.
Yeah.
Sir, why only BCCI will be considered as state under Article 226? Why not in under Article 32?
Yeah, very good. So in this case, that is G Telefilm Limited versus Union of India, the BCCI, it was considered that it is a society. The BCCI is a society which is registered under the Tamil Nadu Society Registration Act of 1975. Okay. So Supreme Court said that the prerequisite for Article 32 is that it should in the prima facie it should be appearing as a state. But BCCI, which was not controlled by the government directly, it was not prima facie appeared to the Supreme Court that it is a state because it was registered as a society under the Tamil Nadu Society Registration Act 1975. So the Supreme Court held that it can be considered as a state under Article 226 and not Article 32 because prima facie it was not to the Supreme Court coming that it is a state. So there is no so the Supreme Court considered that if it is not a state, then there will be no violation of the fundamental right. And under Article 32 and 226, a petition can be filed only if your fundamental right has been violated by the state. So it's what is the result of this that in G Telefilm Limited versus Union of India, Supreme Court held that it will be considered. It means it will be considered as a state only under 226 and not in the Supreme Court under Article 32. One of the reasons that was given by the Supreme Court for this also by the judge, by the honorable judge, was that the workload of the court can also be reduced in this manner. You can check the G Telefilm Limited versus Union of India case judgment from the Indian Qanun. It was one of the reasons given by the honorable judge Pradeep Viswas, honorable. It was given that the workload with the court was one of the reasons for such a decision. It is clearly mentioned in the decision that the workload with the court was one of the reasons for such decision. So it considered to be under 226. Okay, so this was all about Article 12. It is clear to everyone, I hope.
Yes, sir.
Remaining people?
Yes, sir.
Okay.
Yeah.
Now we move to Article 13 of the Indian Constitution. This is a very beautiful law and a beautiful article of our Indian Constitution in which we will be discussing very good and prominent something very good like the rule of severability, what is Doctrine of Eclipse. These are the things that we will be discussing. So in a common hook and crook, you can understand that it states laws inconsistent with or in derogation of the fundamental right are void. It stated that any law which is made by the parliament, okay, any law which is made by the parliament which are in derogation of the fundamental right, okay, they will be considered as a void. It is Article 13. See what is said. All law enforced in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall. In this part, matlab fundamental right. Okay, guys. I know you would not be knowing what is in this part. Of this part, matlab hota hai fundamental right, है ना? That is part 3 of the Indian Constitution. Part 1, Union and Territory. Part 2, Citizenship. Part 3, Fundamental right. So all laws enforced in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. Article 13 clause 2 states that state shall not make any law which take away or abridge the right conferred by this part, or any law made in contravention of this clause shall to the extent of contravention be void. This line is very important, guys. Shall to the extent of contravention. From here comes the doctrine of severability that we will be discussing in the next 4 to 5 minutes. Not more than in the next 2 to 3 minutes, we will be discussing what is the doctrine of severability. So it is telling that to the extent of contravention means only that part will be considered void which is against the fundamental right, not the whole law. That is doctrine of severability. We are coming very soon. Now, 13 clause 3 state, unless the context otherwise require, law include any ordinance, order, bylaw, rule, regulation, notification, custom having territory of India the force of law, laws in force included, law passed by the legislature, competent authority in India before the commencement of this constitution. So it tells that law, यहाँ पे what is the meaning of the law? Law is also the ordinance. Ordinance, I hope you must be knowing what is ordinance. Ordinance is when the house is not in the parliament. है ना? Yesterday, the Lok Sabha and Rajya Sabha has been adjourned synodian. So, until the next notice, it has been adjourned. So, the monsoon session is over. Now, they will be meeting for the winter session. We know we have 3 sessions for the parliament: budget session, monsoon session and the winter session. So, when the Lok Sabha and the Rajya Sabha, that is the house of the parliament, is not in session, that time the government can, means the president can issue an ordinance. The best example of ordinance is your triple talaq. You must remember when the triple talaq ordinance was brought, at that time the Lok Sabha and the Rajya Sabha was not functioning. So whether it is an ordinance, whether it is an order, whether it is a bylaw, rule, regulation, notification, and even custom. Now, what is custom? This you will study in semester 1 of any law college under the legal method subject, that is custom. Custom is something which is coming from generation to generation, okay, which has been given a space of law. They are considered as a law, not directly in any of the IPC. Custom is something which is not mentioned in the IPC, CRPC or Indian Evidence Act, but it is coming from the generation to generation to generation for many years. So they are taken into consideration while deciding any matter. That is custom. So any ordinance, order, bylaw, rule, regulation, notification, custom, they are considered law. Now the fourth is that nothing in this article shall apply to any amendment of this constitution made under Article 368. It tells that nothing in this article shall apply to any amendment of this constitution. We know in the Keshwanand Bharti case that we have discussed yesterday, we know that under Article 368 of the Indian Constitution, Keshwanand Bharti versus Union of India case that we have discussed yesterday, it was in this case that the preamble can be amended except the basic structure of the Indian Constitution. So the amendment provision is under Article 368 of the Indian Constitution, and Article 13 clause 4 states that nothing in this article. Now nothing in this article is the other name of notwithstanding. This other term that you will be learning in the law school. Notwithstanding, matlab ki nothing in this article will be applied to the amendment which are made under Article 368, which take us to the topic of Doctrine of Favorability. The Doctrine of Severability came in the case of State of Bombay versus F.N. Balsara. That is a 1951 judgment of the Supreme Court. Okay, you don't have to remember the case. State of Bombay versus F.N. Balsara, in which the Supreme Court held, guys, that whenever any law, means whenever any petition is brought before the Supreme Court regarding the constitutionality of any law, because we know that 13 is telling what? That any law, law inconsistent with or in derogation of fundamental right is void. Now, if a petition is brought before the Supreme Court today that, sir, this law is in contravention to our fundamental right. Now, the Supreme Court will not make the whole law as void. Only that part of the law will be made void which violates the Indian Constitution. I am repeating it. According to Doctrine of Severability, whenever any law is brought to the Supreme Court that this law is against our fundamental right, the whole law is not made void. The Supreme Court go into the depth of the law and make that law, that provision only unconstitutional. Struck down only that provision which is unconstitutional. Take the example of 377. That is the National Legal Service Authority versus Union of India. That is the homosexual case. So in that case also the whole Article 377 was not considered as unconstitutional. Okay, only the 377 clause 1 was struck down by the Supreme Court. The whole 377 was not struck down. Only 377 clause 1 was struck down. So that is the example of the Doctrine of Severability. Whenever any law is brought to the Supreme Court, the whole law is not declared void. Only that provision of the law is declared void which violates the Indian Constitution, which we come to Doctrine of Eclipse. Eclipse, I hope you know what is eclipse. Eclipse matlab pata hi hoga. So take the example of the eclipse that you know. It is held by the Supreme Court that any law which is inconsistent with the fundamental right, it is not dead altogether. The Supreme Court told that if any law is inconsistent with the fundamental right, means it is an unconstitutional law, so it is not dead altogether. It is just overshadowed by the fundamental right, and it remains dormant. Eclipse ka matlab I hope you must be knowing. Okay, eclipse you know no. So in the similar manner, it is telling that just as the sun and the moon eclipse happen, in the similar manner the laws are overshadowed by the fundamental right, and that laws become dormant, not dead. Now in future, if any right, means if any determination of right appear before the Supreme Court can use that particular law once again. So it does not become dead, it becomes dormant. So that is the doctrine of eclipse. That is the overshadowing of that particular law which was considered inconsistent with the fundamental right. With the fundamental right, it is overshadowed by the fundamental right and it remains dormant. So that is the crux of section 13, that any law which is in contravention to the fundamental right will be declared void. In contravention, into the extent it is in contravention, not the whole law. That is the doctrine of severability, not the whole law, but only to the extent of which it is void. Okay, guys. So Article 13 is clear.
Yeah.
Yeah.
Sir,
Yeah.
Sorry to interrupt, but after Article 368, you have written Keshanand Bharti versus Union of India. It is State of Kerala.
Yeah. Actually, most of the cases are related to Union of India, so that's why it is Keshwanan Bharti versus State of Kerala. Yeah, thank you. Yeah,
sir,
yeah.
doctrine of eclipse will be applied to post-constitutional law or not?
Very good. So it was in the case of Bhikaji Narayan Dhakras versus State of Madhya Pradesh, where the Supreme Court held, okay, that the post constitutional law will be coming under this doctrine of eclipse. In the Bhikaji Narayan Dhakras versus State of MP, it is the case of 1955 in which the Supreme Court held that even the amendment or the act which come after the constitution, on that also the doctrine of eclipse will be applied. Okay, Suruji?
Yes, sir.
Thank you. Now we come to Article 14 of the Indian Constitution, which we all know from class 8 and 9, that is, the state shall not deny to any person equality before law or the equal protection of the laws within the territory of India. The state shall not deny to any person equality before law or equal protection of the law. Now, here what happened, the Supreme Court told that Article 14 is an article which is applicable even to the non-citizen. So it is sometimes asked in the polity question of the various examination that which of the following article is applicable even to non-citizens. So it is one of the article, not it is not only the article, not the only article, it is one of the article which is applied to the non-citizen. So Article 14 is applicable to the non-citizen, then it is applicable even to the transgender. Okay, it is applicable even to the transgender, which was held in the National Legal Service Authority versus Union of India case of 2014. National Legal Service Authority versus Union of India case 2014, it was held that Article 14 is applicable even to the transgender. This is a very important case, National Legal Service Authority versus Union of India, that is 2014 judgment, in which it was held by the Supreme Court that this Article 14, apart from non-citizen, it is also applicable to the transgender. So this is about your Article 14. Nothing more is there in Article 14. Just you have to remember what is the what is Article 14. Just you have to remember that. Now we come to Article 15. That is, it prohibits the state to discriminate any citizen on ground only on religion, caste, place, sex, place of birth. Article 15 clause 1 states that the state shall not discriminate on the basis of religion, caste, sex, place of birth. It was held by the it is in Article 15 clause 1, and it was held in D.P. Joshi versus State of Madhya Bharat. This is a case, D.P. Joshi versus State of Madhya Bharat, in which it was held that there is a difference between place of birth and residence, and the Article 15 does not talk about residence. This is very important question, that whether residence come under your Article 15. No, it is the place of birth where you take your birth. If you are a citizen of India, that means, now you reside in Gujarat, you reside in Jharkhand, you reside in UP, that is not an issue. The place of birth will be, there should be no discrimination on the place of birth. So in D.P. Joshi versus State of Madhya Bharat, there was a circulation in the medical college regarding your state of residence, there was a discrimination based on residence. In that case, DP Joshi versus State of Madhya Bharat, the Supreme Court held. Second, 15 clause 2 tell that this article further state that no person shall on any ground be denied access to shop, school, places of public entertainment, use of well tanks. Now, the public shop, hotel, places of public entertainment, no, there should be no discrimination in that. Sorry. 15 clause 3 state that in this article, here will be nothing. Nothing in this article shall prevent the state from making special provision for women and children. We see that from the reservation of the seat for the women in the Panchayati Raj system, then in the not in the, we don't have in the parliament, but it should be in the parliament. Then in various places there is the reservation especially for the women. You take the example of even the local trains where one whole bogie is for the women and for the children. So it tells that there should be no discrimination on the basis of sex. 15 clause 1 tells that it prohibits the state to discriminate any citizen on the ground of sex. But it tells that nothing in this article shall prevent the state from making special provision for women and children. That is 15 clause 3. Now 15 clause 4 it tells that nothing in this article or in clause 2 of article 29 shall prevent the state from making any special provision for the advancement of any socially or educationally backward class of citizen, scheduled caste and scheduled tribe. That is the article of reservation. Guys, the reservation article is 15 clause 4 in which the Supreme Court, in which it is stated that the state can make special provision for the socially and educationally backward classes of citizen or the scheduled caste or the scheduled tribe. We must know the Indira Swane judgment case, Indira Swane versus Union of India. Recently, we have the Maratha judgment also, in which it was held that 50% is the cap. No reservation can exceed the 50% cap, in which it was held in the Indira Swane case. So that is the special provision for the socially and educationally backward class. This is the provision of the reservation. Always remember. And then the 15 clause 5 is also related to the scheduled caste and scheduled tribe for the advancement of the scheduled caste and scheduled tribe in the educational institution. That is article 15. So you have to remember what that 15 talks about the no discrimination on the ground of religion, caste, sex, place of birth, but it is not residence, entry to the shop, special provision for the women and children. Okay, if ever means at that time what happened, many petitions were filed in the Supreme Court when the special laws were made by the Parliament for the women and children. Now in that case, Supreme Court used this article 15 clause 3 that nothing in this article shall prevent the state from making a special provision for women and children. And then we have the reservation under article 15 clause 4 and we talk about the Indira Swane versus Union of India. Now we come to article 16. Article 16 is your equality. It talks about your equality of opportunity in matter of public employment. Okay, so article 16. It states that there shall be equality of opportunity for all citizens in matter relating to employment or appointment to any office which is under the state. Now state here means, now we know, see this is the thing guys. What is the meaning of the state? We have discussed in the beginning of the class. Under article 12 of the Indian Constitution, we know what is the state. It can be the parliament, it can be the state legislature, it can be the municipality, it can be the panchayat, it can be any of the institution, even the educational institution which come under the government of India. So it tells that there should be equality of opportunity for all citizens in matter relating to employment. Then 16 clause 2 states that no citizen shall on ground only of religion, caste, sex and a decent place of birth be ineligible for or discriminated again in respect of employment or office. That was 15 clause 2. That there should be no discrimination. Now this talk about the employment of the people. Here also it states that there should be no discrimination. Then come article 16 clause 3. Nothing in this article का another नाम होता है notwithstanding shall prevent parliament from making any law prescribing in regard to a class or classes of employment or appointment to any office under the government or any local or other, that is the whole topic of the state, means from the parliament, state legislature, local authority. It tells that any law can be made regarding employment by the government. Then Nothing in this article shall prevent the state from making any provision for the reservation of appointment or post in favor of any backward class of citizen, which in the opinion of the state is not adequately represented. Guys, remember the Maratha judgment. It was stated by the Maharashtra government that the Maratha community is not adequately represented. But the Supreme Court told that there is no such report or something like that. Even the Gaekwad Commission has stated, but Supreme Court told that there is no such report which says that this particular Maratha community is not adequately represented in the state. So this is Article 16 Clause 4, which the Supreme Court took the example of, that nothing in this article shall prevent the state from making any provision for reservation of appointment or post in favor of any backward class of citizen, which in the opinion of the state is not adequately represented. Now various judgment came afterward, in which it was held that opinion of the state should be backed by a data. ऐसा नहीं है कि आके अगर स्टेट बोल दिया कि इट इज नॉट एडिक्वेटली रिप्रेजेंटेड तो नहीं, then it will be the misuse of political power, है ना. So it held that there should be a data. It was held afterward, but this is our constitutional provision, and that is Article 16 Clause 5. That is not so much importance. It is regarding the law and the office only. So basically 16 is about the equality of opportunity in matter of public employment. Then we come to the very easy and simple article of the Indian Constitution, which talks about the abolition of untouchability. We must remember Gandhiji and Harijan case. So it states that untouchability is abolished and its practice in any form is forbidden. Article 17 of the Indian Constitution states that the abolition of untouchability, any form, it is not allowed in any form. Okay. Untouchability, we know what is untouchability, wherein a particular community, okay, they are made to feel down, they are made to feel oppressed, they are being treated in a different manner, they are don't allowed to enter the village, they are don't allowed to use the well. So this was the thing that all was happening in, so it Article 17 state that the old practice of untouchability should be abolished. And then we come to article number 18, which is abolition of title. That is, the state should not confer any citizen of India. It prohibits the state from conferring any title. Article 18 states that no title, no title shall be conferred by the state, and citizen of India, they cannot even accept title from any foreign state. They cannot accept title even from any foreign state. But it was held that military title and academic title and the Bharat Ratna, Padma Vibhushan, okay, they are not, matlab, they are something which is considered to be the, they are something to be considered as an academic title, है ना. But you cannot write that Bharat Ratna Manohar Parrikar or Bharat Ratna APJ Abdul Kalam. If it is a military title like Major General Singh, है ना, Major Karamveer Singh, or academic title like Doctor, है ना, Doctor Harshvardhan, or like many other academic title are there. Okay, they write the professor something like that, or doctor or PhD this. So these are the something which are academic distinctions, and military distinction like major, lieutenant. This can be conferred, but you cannot write Bharat Ratna this. Padma Vibhushan this. They are, although means they are given as a respect, but it will not be considered, means you cannot use it as a title. So Article 18 prohibits the state from conferring any title, and even our citizen cannot accept any title from the foreign state. Okay. Another important thing is, it is not mentioned here. 18 clause 3 talks that no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, accept without the consent of the president any title from any foreign state. Means you are not an Indian citizen. Okay, very good. You are not an Indian citizen. That is okay. But if you are working under our state government, state, everywhere in the constitution it is written state, and you must be knowing what is state. So if you are working under our state, then you cannot accept any title without the permission of the President of India. So this was Article 15, 16, 17, 18. That no discrimination on the ground of this, equality of opportunity in matter of public employment, abolition of untouchability, and the abolition of title. Okay, this all articles are clear, I hope, to everybody. Yeah, Kinjla, do you want to share the screen? Okay, okay, no issue, no issue. So still it is 8:40. Now we have done with this. Now we come to the very famous fundamental right of the Indian Constitution, that is your right to freedom. Right to freedom under Article 19 to Article 22. From Article 19 to Article 22, we have the right to freedom. So first we have the Article 19. Let's start with Article 19. The right to freedom guarantee to the citizen of India six fundamental freedom. The first is the freedom of speech and expression. फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन। मैं ये डेमोक्रेटिक कंट्री है, मुझे जो मन में आएगा मैं बोलूंगा, मुझे जो मन में आएगा मैं एक्सप्रेस करूंगा। आई विल बी टेलिंग अगेंस्ट द आर्मी, आई विल बी टेलिंग अगेंस्ट द पॉलिटिकल पार्टी, आई विल बी टेलिंग अगेंस्ट द स्पीकर, आई विल बी टेलिंग अगेंस्ट द जजेस ऑफ द सुप्रीम कोर्ट एंड द हाई कोर्ट, आई विल बी टेलिंग अगेंस्ट अ कॉमन मैन, आई विल बी टेलिंग अगेंस्ट द टीचर, आई विल बी टेलिंग अगेंस्ट माई फ्रेंड। So that is the freedom of speech and expression. So it's still that freedom of speech and expression, Article 19. Yeah, just a minute. So it is the freedom of speech and expression which comes with 1B, that is reasonable restriction, in which it is stated that nothing in the subclause A of clause 1 है ना, shall affect the operation of any existing law or prevent the state from making any law in the interest of the sovereignty and the integrity of India, the security of the state, friendly relation with the foreign state, public order, decency, morality, or in relation to contempt of court, defamation, or incitement to an offense. You are given the freedom of speech and expression, but it comes with a reasonable restriction under clause B. We state that your freedom of speech and expression should not be such that it goes against the sovereignty and integrity of India. It should not go against the security of the state. It should not go against the friendly relation with the foreign state. It should not be an incitement to violence. It should not be against the public order. It should not be against the morality. It should not be a contempt of court. It should not be a defamation to others. Okay. Then we come to the case of the Ramesh Thapar versus State of Madras. This is a case in which the Supreme Court told that freedom of speech and expression include the freedom of speech and expression of the press. The Indian press also have the right freedom of speech and expression, because you must remember the emergency time in which it was held that any article that will be published in the newspaper should be having the consent of the government. In that case, the Supreme Court held that freedom of speech and expression comes also for the press. The Indian press also have the freedom of speech and expression. So that is the freedom of speech and expression. We talked about the reasonableness. Now the reason, another very important thing is the reasonableness, the reasonable restriction. There should be a proportional representation. Means the limitation that has been imposed upon the enjoyment of the right, it should not be arbitrary. It should not be excessive in nature. You must know the article of section 144. Section 144, you know, the most commonly you call धारा 144 है ना, धारा 144 लग गया है, you tell. So that is section 144, in which the assembly of 5 or more people is prohibited by the executive magistrate. Now there also it tells that for the section 144 it should be a written permission. Apart from the emergency case, it should be a written permission, and there is a limit prescribed for section 144 also. So the reasonable restriction should be something which is not arbitrary. It should not be excessive in nature. Then we discuss the Ramesh Thapar versus State of Madras, in which the Indian press was included under the freedom of speech and expression. Then we come to the right to know. Right to know also come under the freedom of speech and expression. That is the RTI. You must know the Rti Act 2005. Okay, in which from any public authority you can demand any answer. Then you have the right to remain silent. Right to remain silent means that it is not, if you don't want to speak to anyone, if you don't want to listen to anyone, okay, if you don't want to speak to anyone, if you don't want to listen to anyone, it also come under Article 19 clause 1, that is freedom of speech and expression. Then we come to the very famous case of the Shreya Singhal versus Union of India. In the Shreya Singhal versus Union of India, see what a coincidence. Today the Supreme Court judge, the respected Honorable Justice R.F. Nariman, has retired at 3:30 p.m. from the Supreme Court, and he was one of the judges in the Shreya Singhal versus Union of India. So Shreya Singhal versus Union of India was the case in which section 66A of the Information Technology Act was struck down by the Supreme Court, because according to the Supreme Court, it violated the Article 19 Clause 1A, that is freedom of speech and expression. It violated the Article 19 Clause 1A, that is freedom of speech and expression. So Supreme Court struck down that Section 66A of the Information Technology Act in the Rti Single versus Union of India. So that is 19 Clause 1. Then we have the freedom of assembly. Okay, we can assemble anywhere we want in the country. Okay, wherever we want we can assemble, we can take out any procession, any religious procession can also be taken out. Now you cannot state that this is a Hindu dominated region. Okay, you cannot state that this is a Hindu dominated region, so only Hindu will take out the procession, or this is a Muslim dominated region, only Muslim will take out the procession. So freedom of assembly is any people can assemble, but there also it comes also with a limitation. Then you have the freedom to form association. All the companies, all the unions, the traders, they have the right to form association. And there is a case, very famous case, in which the Supreme Court held that if you are a union, you must be knowing the trade union. So if you are a union, you are not losing your fundamental right. Because what is union? Union is a collaboration of many individuals, and every individual in that union or the association have a fundamental right. So even if you form a union or association, you do not lose your freedom of the fundamental right. Then you have the freedom of movement. The very famous, you can move in any part of India wherever you like. You can go, but there are certain restrictions in states like Nagaland. Okay, in which it is that if you stay for more than 24 hours, okay, that we will see this freedom of movement and freedom to reside and settle are more or less, they are closely related. So right to movement is that you can move to any part of the country wherever you want, but there are some certain state like Nagaland, in which it is held that if you want to reside in our country, in our state, then you have to take the permission of the government. Okay, there is a very famous case of Kharag Singh versus state of UP. This is the case of police surveillance. Okay, even those who were the part of Clat 2021, we have discussed that the case of state surveillance, police surveillance. Okay, so police surveillance means the police, if you are a habitual offender or if there is a criminal record against you, then the police will be tapping your phone, police will be following you, police will come and interrupt in your home. Okay, so if you are an habitual offender, in that case the police keep on moving behind you. In the Kharag Singh versus state of Uttar Pradesh, the Supreme Court told that the watching and the shadowing of such person who are an offender does not violate the right to movement. It does not violate the right to movement. The Supreme Court tells that this is a case, this is a thing which is regarding the case, means for the petition because he is an habitual offender. That is the result of which the surveillance has to be kept, and it is necessary. So it does not violate freedom of movement. And then we have the freedom to reside and to settle even in the state of Jammu Kashmir. After 5th of August 2019, we can even reside in the state of Jammu Kashmir except Nagaland, where there are some provision for which you have to take the permission of the government of Nagaland if you want to stay for more than 24 hours. And the last is the freedom of profession, occupation, trade or business. Whatever occupation you want, whatever profession you want, you can carry whatever profession you want, whatever occupation you want, whatever business you want, you can carry on there. Okay, now there was a very famous case there is a very famous case, I don't remember, regarding the freedom of profession and occupation. It was asked by the Supreme Court that whether education should be considered as a form of occupation or a business. So in reality, it is a business. We all know that education, whether you take the coaching center or whether you take the school or whatever it is, in reality, it is it comes under, it should come under 19 clause 6, but the Supreme Court told that no, the school, whether it is aided or unaided school, education cannot be considered as something for profit. Supreme Court told, yeah, I have got the case. You don't have to remember, just I am giving you the case name. That is Islamic Academy of Education versus State of Karnataka. That is the 2003 judgment. So in the Islamic Academic of Education versus State of Karnataka, the Supreme Court emphasized that the education should not be considered something for profit, although in reality it is. But Supreme Court told no, it does not come under 19 clause 6. So freedom of this freedom article, that is 19 article, is a very important article, right to freedom, which talk about freedom of speech and expression with the reasonable restrictions. Then we talk about Ramesh Thapar and State of Madras. Sriya Sringal, the very famous judgment. Freedom of assembly, freedom to form association, freedom of movement. We talk about Kharag Singh, the right of the police to surveil in the surveillance topic, freedom to reside and settle even in Jammu Kashmir, and freedom of profession, occupation, and trade of business. These are the 6 fundamental freedom that are given to a citizen of India, only to a citizen of India. Always remember, the reasonable restriction that has been talked here, it should be not arbitrary, it should be proportionate. Okay, the objective, what is the objective of that reasonable restriction, it should be taken into consideration. So I hope 19 is clear to everybody. Yeah. Okay. No, we will just discuss the article 20 and then we will stop. From tomorrow we will start article 21. So article 20 is also a very beautiful article of our Indian constitution. So it is, article 20 is talks about the protection which are given to the convicted for the offenses. Whoever is convicted for any offenses, they are given protection. Let's read 20 clause 1. No person shall be convicted of any offence except for violation of the law in force at the time of the commission of the act charged as an offence, nor be subject to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. This is called ex post facto law. Ex post facto law. What is the meaning of this? It states that, for example, I am giving you the example. Today I commit the murder of somebody. Now, as of now, today, the punishment for murder is imprisonment for life. Although under Article 302 of the CRPC, the punishment for murder is the punishment for murder is death penalty, okay, or life imprisonment, or up to and the fine. So just for today I murder somebody, and as of now, means today, the provision in the IPC and CRPC is that the punishment for the murder is only life imprisonment. Okay, now tomorrow the government brought an amendment to the IPC, CRPC and stated that under section 302, whoever murder anybody, he will be given death penalty. But I will only be charged with life imprisonment and not with death penalty. Now this was the second part. The first part was, for example, today I did cybercrime, and today in India there is no law regarding cybercrime. There is no provision in the Information Technology Act nor any under the IPC or the CRPC regarding cybercrime. For example, today I committed cybercrime. The government came to know that yes, cybercrime is a thing happening. On 15th of August, on the eve of Independence Day, the government brought the cybercrime Security Act 2021. Now I will not be charged with that act. I will not be charged with that act because I have committed the cybercrime on 12th of August. The act was brought by the government on 15th of August. That is 20 clause 1 ex post facto law. No person shall be convicted of any offence except for violation of the law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. See, whether you become a criminal lawyer, family lawyer, whether you become a civil lawyer, whether you become a legal advisor, for everything you have to take the help of the Constitution. If you are a defense lawyer and tomorrow your client is getting a punishment which is greater than what was during the commission of the offence, you will be taking the help of Article 20. So whichever lawyer, whichever judiciary judge you become, you have to take the example of help of the Constitution of India, the important article. Now the second is no person shall be prosecuted and punished for the same offense more than once. That is double jeopardy. This is double jeopardy. Now here it is prosecuted and punished. What is the meaning of prosecuted and punished? There is two things. One is an allegation, an FIR has been filed against you. That will not come under 20 clause 2. An FIR has been filed against Akshit. Okay, that he has committed theft. And again tomorrow another FIR has been filed against Akshit in Bombay. This FIR was filed against Akshit in Bangalore, and tomorrow against another FIR has been filed against Akshit in Bombay, that Akshit has done theft. This now Akshit lawyer, the defense lawyer, cannot claim Article 20 clause 2 because it clearly mentioned that no person shall be prosecuted and punished. Prosecuted and punished. You cannot be prosecuted and punished for the same offense more than once. That is double jeopardy. Today I have committed murder. I have been charged with life imprisonment. Tomorrow is that life imprisonment, not life imprisonment. You take the example of imprisonment for 10 years. Today, 12th of August 2021, I committed murder and I am charged with imprisonment for 10 years. On 12th of August 2031, Akshit filed a case against me that this person has committed murder on this date. Now again I will not be punished for the same offense because I have already been punished for my murder that I have committed on 12th of August 2021. I have been charged with the imprisonment for 10 years. Now that petition of Akshit that I should be again punished, that will not be taken into consideration. Now my defense lawyer will use Article 20 clause 3. Now another important thing that come in Article 20 clause 3 is S.A. Venkataraman versus Union of India case. This is a very famous case. S.A. Venkataraman versus Union of India case. What happened in this case? There was a charge against a employee of an office. Just give me a minute. I'm telling you the facts of the case. Yeah. In S.A. Venkataraman versus Union of India, okay, an inquiry was held against the appellant under the Public Servant Inquiry Act 1850. Okay, there was an inquiry, there was an employee named S.A. Venkataraman. An inquiry was held against him, and as a result of the inquiry, he was dismissed from his office. He was dismissed from his office. It is a very simple thing that tomorrow, if an inquiry is set up against you, if a police FIR is against you, or if you are convicted of any offense, at that time only you have to resign from your post, or you will be removed from your post. Either of these things together. So when an inquiry was initiated, for example, if we take an example of anyone, yeah, an inquiry was initiated against Kashish. Okay. Now the company in which Kashish, the law firm, the biggest law firm of India in which Kashish was working, he was dismissed from there. After today this was happened. Tomorrow what happened? A charge sheet was filed by the police for the same case. A charge sheet was filed against Kashish for the same case regarding the offense that she has committed under section 161 and 165 of the IPC. Now you don't have to know what is 161, 165. It is related to corruption. Okay, 161 and 165 of the IPC is related to corruption. This all you don't have to know now. You will be learning this in the law school. So first of all, what happened? An inquiry was initiated against Kashish. She was dismissed from the biggest law firm of India. And after that day, today this was done. Tomorrow the police filed a charge sheet under section 161 and 165 of the IPC for corruption. Now Kashish's defense lawyer filed a petition in the Supreme Court that this is against Article 20 clause 2. But it was held by the Supreme Court that no sir, this is not against Article 20 clause 2. Because that was not a judicial punishment and prosecution. Although you were removed from your, although Kashish was removed from the biggest law firm, but that was not a judicial punishment or prosecution. It was your official, the office to which you belong, the law firm to you belong, is just for your official sake. But this is the judicial conviction, this is the judicial punishment. Now if any charges is levied against you on this basis, then it will be considered that it goes against article 20 clause 2, but that is not that. So two things you have to remember under 20 clause 2, that mere allegation or FIR does not bring the defense of article 20 clause 2. There should be a prosecution and punishment. And second is that the S.A. Venkataraman versus Union of India, in which we took the example of Kashish, that he was dismissed from the biggest law firm of the country, but that is not a judicial process. The next day when the charge sheet was filed and the Supreme Court took the petition, that time, and she was punished for that, that is the case of the judicial. After which, if something happens like that, then she will be saved from by the defense lawyer under 20 clause 2. And the last is, no person accused of any offense shall be compelled to be a witness against himself. See, Kanish always tell that law is the game of words, and it is often told by many of the various honorable judges of the Supreme Court, lawyer, that law is a game of words. Now see, when it was written here, it was something like this: no person accused of any offense shall be compelled to be witness against himself. If this would have been the provision in the Indian Constitution, it would have been inferred in a different way. But the provision in the Indian Constitution, guys, is this: no person, comma, accused of any offense, comma, shall be compelled to be a witness himself. मतलब कि पहला है कि कोई भी पर्सन हो, any person, no person, है ना, not a single person who is accused of any offense, he or she shall be compelled to be a witness against himself or herself. That is self-incrimination. This is the theory of self-incrimination. Means if a police is interrogating you, if the police is interrogating you, then you should not give such facts of the case or such answers that can bring a case against you. Okay, if a police is interrogating you, you are not compulsory, you have to tell all the facts or all the whatever it is related to the case that can bring a case against you. You are not liable for that. So that is self-incrimination, that no person accused of any offense shall be compelled to be a witness against himself. You give witness, Kashish can give witness for Priyamvada, Kashish can give witness for Hinduja. But when the police will personally interrogate Kashish, then if she does not give the answer, then she cannot be compelled to do so because of the Article 20 clause 3, that is self-incrimination. You should not give that fact of the case, you should not state that fact of the case which will be a loss for you, which will prove a negative for you. So that is Article 20. This is a very important and very beautiful article of the Indian Constitution. That is the protection in respect of conviction for an offence, in which we discuss ex post facto law, then we discuss the double jeopardy and self-incrimination. We stop here, then tomorrow we will be discussing Article 21.